We are
Classy.
live.
Hey, good morning, everyone. This is Vermont House Committee on Commerce and Economic Development. It's Thursday, April 13th, 2023 at 10:50 in the morning. So now we're switching gears again and continuing our discussions on H81, which is the fair repair of agricultural equipment. So we have Justin Colbert from joining us this morning. I think trying to figure this out. And I think some of the discussion has been, intellectual property, how that works within the confines of the bill. And our hesitancy, the possibilities of lawsuit against the state. So thank you for joining us this morning.
Sure, glad to be here. I'm happy to dive into questions or give you an overview. I've done an overview before with the House Ag Committee, if that's helpful.
That would be helpful for us as well.
Okay, great. And just to reintroduce myself, Justin Colbert with the Attorney General's Office. I am the chief of our Environmental and Public Protection Division, which also includes our Consumer Protection Unit. And that's the position I'll be speaking from today, is our Consumer Protection Authority and perspective. And from that perspective, I'll say off the bat, the Attorney General's Office does support the bill, doesn't see any wordsmith or changes that we would propose, but I'll walk through what the bill does and why we think it's good for consumers. And I'll start there because it sort of has two components. One is protecting consumers, particularly farmers and those who are repairing agricultural equipment, but it's also good for fair competition and an even-handed business market. And I'll explain that as well. The bill is trying to provide fair access to repair of agricultural equipment, parts, equipment, instructions, things like that. And in that realm, there's a growing movement. As you folks know, the right to repair movement generally is really been an important consumer movement over the last few decades, and particularly around vehicles and farm equipment specifically. I'll note that our office did join a federal, a multi-state letter to the federal government supporting federal legislation in this area as well. That was joined by numerous states. So our office is very supportive of this approach of giving consumers the right to repair their own equipment. And in that letter, we did note some of the concerns that have been identified around the fact that companies are holding on to their repair parts and access and effectively creating monopolistic tendencies. The Federal Trade Commission, who we work closely with, they noted some of the harms to consumers, particularly around agricultural equipment and vehicle equipment. As that equipment becomes even more technologically advanced, as you get even more embedded electronics, the FTC identified lots of harms and concerns that can arise around that. Prices go up, competition is limited. Some of the methods that companies have been using that the FTC has identified are using adhesives to make parts difficult to replace. That's been one unfair method, limiting availability of parts and tools, and making diagnostic software unavailable. So we think this bill is good to combat those harms and concerns. Another, I think, important statistic the FTC noted is that the cost of repairing equipment has gone up 66% since 2000. So again, some of the real important reasons why a bill like this is helpful for consumers. You're going to drive prices down, and you're going to help break up any monopolistic tendencies around information manuals, parts, tools, etc. So that comes from our consumer protection perspective. I think I'll just move next into some of the legal doctrines that I know there are questions about. And I think particularly there are three that are involved: the Dormant Commerce Clause, the First Amendment, and the Takings Clause. And I did review the record materials, and I did note that David Hall had prepared a very lengthy, almost 30-page memorandum that I think you all have seen and have had access to. So I'll presume some familiarity, and I know you are familiar with some of these legal concepts. So I'll start with the Dormant Commerce Clause. And right off the bat, always the first concern around the Commerce Clause is a bill facially discriminating against other states? Are you actually naming one state over another? So, for example, if the bill said only Vermont OEMs can sell their parts or equipment to farmers, that would be bad. The classic example was the state of Michigan had a law that said only Michigan breweries could sell beer in state, and that discriminates against other states on its face. So this bill doesn't do that. So we're not in that box. So right away, we're going to shift to what's known as the lower standard. It's the Pike balancing test that some of you might be familiar with. That just is the name of the Supreme Court case. And that's a test where the law is even and neutral on its face. It doesn't say New York, you have to do X, or Vermont, you have to do X. Your bill just says any OEM, any manufacturer of agricultural equipment has to do X. So you're in a neutral place for that. And if someone were to try to sue the state over H81 and say, well, yeah, the bill is written neutrally, but really I'm a New York company and I have extra burden to deal with the Vermont market because New York isn't making me do this. Only Vermont's making me do this. So Vermont, you're making me change my practice just to come into Vermont. That's the typical argument you would hear under a dormant commerce clause. And the response to that is we have to analyze, well, is that burden for a New York company, quote, clearly excessive in relation to a benefit to a Vermont company? That's known as the Pike balancing test. Are the burdens on out-of-state companies so clearly excessive to the in-state companies? And what clearly excessive has been interpreted to mean is giving a, quote, distinct competitive advantage to the in-state company. So looking at it through that lens, our office doesn't see how H81, as it's worded, gives any special benefit to a Vermont company over a New York company. Again, the law is neutral, so any manufacturer of farm equipment will have to comply with this. So we don't think a court would see that as being a clearly excessive burden on an out-of-state company, particularly because a Vermont company isn't gaining a special benefit. And again, the benefits are important. That would be part of the test as too. The benefits that I mentioned are protecting consumers, lowering costs. There may be health and safety issues around giving people access to parts that they need, and providing fair competition among companies. So those are all valid benefits that courts have looked to as well when they do that Pike balancing test. Now, another form of the Dormant Commerce Clause is also known as extraterritoriality. And that would be the idea that a company is going to come in and say, well, Vermont, you're really trying to regulate outside your boundaries. You really are trying to regulate New York companies and Michigan companies and Wisconsin companies. And that has also been fairly litigated and settled. We have a couple of cases that came from the state of Vermont. One was around the labeling of mercury lamps, and the other was around the labeling of genetic modified foods. Both those cases were litigated under that issue. And there's a really close analogy to the mercury lamp case where Vermont was saying anyone who's going to sell a lamp that has mercury has to label it. And companies outside of Vermont said, well, you're really regulating us outside of Vermont. And the courts have said no. Because the law was neutral and applied to both companies, it was only requiring labels for any company that happened to do business in Vermont. And if a company, let's say a New York farm company says, well, you're forcing me to change my practices to come into Vermont, courts have said, quote, if manufacturers don't want to come into the state, that's because they're unwilling to modify their production and distribution systems to differentiate between Vermont and non-Vermont systems. So a company can't just come in and say, well, I'm based out of Wisconsin and your law is forcing me to change my practice. That's been upheld under the Dormant Commerce Clause to say that's exactly the purview of states to do that. It's up to the company to choose whether it wants to sell its products in Vermont or provide farm equipment to Vermont. So you're not telling another company in another state that they have to do something. You're only saying if you sell to Vermont, then you have to comply with our law. And another argument that was raised in these cases, in the GMO case, companies said, well, this law is encouraging out-of-state manufacturers to abandon a state market. The court also rejected that argument, right? The idea that, well, if you're going to make the cost of entry into Vermont higher, because now I have to comply with H81, well, I can't come into the Vermont market, and that should be unconstitutional. And the courts have said, no, that's, again, up to the producers to make that choice, and that any company, whether you're inside or outside of Vermont, face, quote, the same putative need to develop a separate system to accommodate the Vermont market and other state markets. And it was similar in the genetic modified food space. Vermont had a law that required GMO labeling, and companies challenged that and said, hey, I'm Pepsi-Cola, I'm based out of Georgia. You can't, or Coca-Cola, based out of Georgia. You can't require me to put that label on. And the court said, Vermont can do that. It's up to the company to choose to modify its distribution system for each state. So it's perfectly valid for states to have sort of a different patchwork of requirements that companies have to comply with. Another argument that has been made around Commerce Clause argument is, well, you're raising the costs because of this new Vermont regulation and we're going to have lower profits. That was also litigated in these cases. This was the Mercury Lamp case and the GMO case. And the court said that, quote, just because manufacturers must bear some cost of Vermont regulation in the form of lower profits does not cause a statute to violate the Commerce Clause. And then another argument that has been raised is the Vermont law creating some kind of conflict with other laws that companies have to comply with? So again, let's look at GMO labeling. Companies were saying, well, we also have to label under the FDA. We have to have certain disclosures around calories and ingredients under the FDA. And they were saying, well, isn't this a conflict of food labeling? And the court said, no, again, you need to show a clear regulatory scheme that the Vermont law is now conflicting with. So in our review of right to repair, I don't see another landscape where an OEM has to follow a different regulatory regime around right to repair. In fact, that's part of the reason this bill is being proposed, and part of the reason why the right to repair movement is growing is because there is no regulatory regime around it, right? There haven't been rules or laws around right to repair. So companies have been free to act however they want, and using their own market incentives, it's resulted in some of these negative consequences we spoke about. So I don't see that this law is now going to create some kind of conflict between other laws that companies can comply with. That would be another argument we would normally hear under the Dormant Commerce Clause. We don't see that playing out here either.
Very quickly, and I know it just passed yesterday in Colorado and is waiting to be signed by the governor, but there is now a bill dealing with right to repair in Colorado for agricultural equipment. Snapshot, really quick judgment. Maybe you haven't thought about this a lot yet. Any hiccups there with this language and theirs?
No, I don't believe so. We're aware that Colorado and I believe Minnesota are, so Colorado's great to hear that passed. I know Minnesota was also very close to passing right to repair as well. And that's common. States will have, again, kind of a groundswell of patchwork laws and regulations. And that's totally appropriate because challenges to those laws only come up under each state's purview, right? So a challenge in Colorado would follow the same sort of Pike balancing test as a challenge in Vermont. But just because a Wisconsin OEM has to comply with Colorado and now Vermont separately, that wouldn't make Vermont or Colorado's law more or less unconstitutional. It's the same analysis. Now, what might happen is the federal government might step in and just do more of a comprehensive law, and that is what happened with genetic modified foods. Vermont was the first one. California was very close. Other states were starting to pass them, and Congress just passed a national law. So that might very well happen here, and then we would get into the preemption world, but that's down the road.
So thank you. You were talking about sales, and there's no limitation on sales of equipment once we pass these laws, right? You're talking about how companies have sued saying that you're making it harder for me to sell my equipment. What about use? Because we have in here an owner is an individual or business that owns, purchased, or used in the state. So is that something that could be a problem?
So if I'm understanding that, a company didn't sell equipment here, but it's being used here, and now that company has to provide some kind of instruction manual or something like that. As long as that company is doing business in Vermont and you have some other nexus to regulate that company, then that should still survive any kind of challenge. If a Wisconsin company is not selling to Vermont or have any other Vermont connections here, and perhaps someone bought a secondhand part or a downstream part from that Wisconsin company, you could get into another issue of what's the nexus between that Wisconsin company and Vermont to force them to comply with this. So that just always comes down to sort of a standard test of, is there minimum contacts with a company and a state to have them follow Vermont laws? So I don't know, we wouldn't have any specific proposal for how to change that, but the law is written saying use is not in and of itself a reason why, it would be unconstitutional or invalid. But a company might say, I have no ties to Vermont anymore. I abandoned my business 20 years ago. I don't know how someone got that used part and now they're asking me to repair it. That could potentially be an obstacle that would have to play out under those facts.
But how would that work because now we're not just in a bricks and mortar economy anymore, that the internet plays a factor in this as well. And so if that company sells parts or sells equipment over the internet, even though they don't sell in Vermont, if that is available to Vermonters, then that nexus would then be made.
Perfect. Yes, exactly. So an internet company selling online to the general public basically holds themselves out to all 50 states. So we would have a Vermont connection in that instance.
Unless they had a piece on there that says not available in Vermont or not, because we do see that from time to time. Like
Exactly.
there's companies that decide that they don't want to sell in the certain states because of regulations that the state has.
Exactly. Right. Certainly online sales, you would have that hook for those companies. Yeah. I was thinking of the most extreme example of a company that's basically out of business or not providing any more parts or anything like that. Yeah. So another topic is the First Amendment. We don't see that as a major concern either. Again, I know that David Hall and some of the record materials talked about it. But one of the questions is around the bill also does require disclosures and instructions, and that's typical of consumer bills. And so you might hear companies say, well, if you're forcing me to disclose my instruction manual, you're forcing me to violate my First Amendment rights. You're forcing me to say things. Yeah, I have to give someone an instruction manual. The First Amendment challenges always come down to the level of scrutiny you give them. Governments are allowed to regulate speech. The more stringent the speech regulation is, the higher the scrutiny is from the courts. The highest scrutiny is really when governments start to regulate speech based by its content and differentiating between who can speak and giving favoritism to who can say something. So a classic case that also came out of Vermont was a Supreme Court case where Vermont was trying to prevent data miners from collecting prescription drug information and using that in marketing. And the problem was that the law only prevented the data miners from using that prescription information, but other people could use it, doctors, academics, et cetera. And the Supreme Court struck that down and said that was an impermissible regulation of speech. Here, this bill it's not restricting speech. It's not based on content. You're not targeting speakers differently than others. At most, you're requiring a disclosure of information. Give someone the tractor engine handbook. That is a very neutral requirement. And if this were to be challenged under the First Amendment, that would put it in this lower box of what's known as commercial speech, where governments are free to regulate commercial speech. Again, that mercury lamp case that I mentioned before, that was also challenged under the First Amendment. And it was a similar law. It was a law that said you have to disclose something. You have to say whether the lamp has mercury in it. And that was upheld under the commercial speech standard. And in the GMO case, the Vermont court also noted that I know there's been an issue around trade secrets, so I do want to talk about that as well. There are laws that do require disclosures of products and other commercial information, and that doesn't put it in the box of a higher First Amendment scrutiny. And so the district court in Vermont, when it was ruling on the GMO case, said there are, quote, numerable federal and state regulatory programs that require disclosure of product and other commercial information, and that does not require extensive First Amendment analysis. So you're requiring commercial information. We don't see that would run afoul of First Amendment standards. Now, to trade secrets specifically, I think that's where I do want to touch on because I know there was a question around that. And I think it is important that this bill has the provision that says you are not requiring manufacturers to divulge a trade secret. There have been instances where states have gotten in hot water for something like that. It typically comes up under the takings clause. That's the third doctrine. Dormant Commerce Clause, First Amendment, now we're under takings. Takings is where you'll see a trade secret challenge. Trade secrets are considered property, intellectual property. And so if this bill in any way did require disclosure of trade secrets or intellectual property, you would have a company coming in and saying, you're forcing me to give up my property, and Vermont, you didn't give me a benefit in return. So how is that a proper takings? Government can only take property when you give a benefit. And the closest case where this played out that I want to mention is out of the First Circuit, where the state of Massachusetts was requiring tobacco companies to disclose their ingredients. And some of those ingredients were trade secret intellectual property. And the state law was struck down under the takings clause. The court was very concerned that, again, it was basically taking companies' intellectual property, putting it out in the open market and not giving them a benefit. And even when the state tried to mention, this is for health and safety, the court still said that wasn't enough to establish a benefit. The state of Massachusetts also said that, they can choose not to do business in Massachusetts. The case was Philip Morris versus Massachusetts. If Philip Morris doesn't want to comply with Massachusetts law because they don't want to give up their trade secrets, just don't do business in Massachusetts. And the First Circuit was very concerned about that. They called it, quote, a Hobson's choice, that you either have to disclose valuable trade secrets, or cease doing business in an important market. This is the essence of legal compulsion. And the court also noted that this new Massachusetts law came in a vacuum where there previously hadn't been any other requirements to disclose that information. It was previously what's known as a non-price regulated market. And now these companies have to lose their valuable trade secrets. So that case is a big warning to states to make sure that they're not requiring disclosure of intellectual property or trade secrets because it could be a takings challenge. So I think you're out of that box because you have this clear limitation in section 4054 that nothing shall be construed to require OEMs to divulge a trade secret. And you've defined what trade secret means. So with all of those caveats, we feel comfortable with the bill as it's written. And I'm happy to answer more questions with that, I think.
With the trades, understanding the trade secret line is super important to have in there, but the definition, I'm just curious because we had a witness yesterday who said that based on some Massachusetts automotive law and then the automotive industry in general federally had kind of a previous understanding that was held up in court as far as like what trade secrets meant. So they were in Colorado, they didn't use the definition in their law at all. They did reference it. They didn't put a definition because of that. I'm just curious, we got hung up on it so much yesterday that I don't know, should we keep a definition of trade secrets or rely on kind of the current national understanding of what that is?
I think that is probably a good choice or question for Ledge Council as well. I haven't looked closely at the reference to 9 VSA 4601.
Great.
So I think maybe we'd want to look at that as well. To our mind, it usually is good to reference definitions that are already codified in existing Vermont law. I'm not aware that section 4601 under Title IX has been challenged. So it seems to be a good measure to define something that already exists in Vermont law. Yeah.
Questions?
I just want to say thank you for addressing some of my concerns around the legality or what we've been talking about with regards to H81. You've really comprehensively gone through, especially with regards to the standards higher and lower of the Commerce Clause. So thank you.
Sure. Yeah. So we've seen these doctrines play out. Commerce Clause, First Amendment, Takings Clause, we're familiar with them. They play out in lots of commercial activities where states are passing laws that are requiring companies to do something, particularly out-of-state companies. And there's nothing sort of inherently unconstitutional about that practice. States are allowed to develop their own patchwork of laws and regulations. Companies can choose to do business with them. And of course, there are some restrictions, like we just mentioned trade secrets. That's where companies are going too far. You're saying you're really taking something from a company. But the mere neutral application of this law, disclosures to consumers, all of those are valid benefits that have been upheld in other contexts and we think would survive here. And we think they're important consumer benefits for the reasons I outlined when I first began. You're really helping consumers and farmers have access to appropriate equipment, and you're preventing monopolistic tendencies, and you're helping fair competition. And we think those are really important state benefits.
Just I was wondering, and maybe not on the spot, but as far as the AG office's opinion on, so in our bill we call out just like technology, and we say if something is locked with technology. But in like the Colorado bill, for example, they go into like embedded software and firmware updates and all the other stuff that can really like strangle and more specifically. And I'm just curious, is the word like quote unquote technology enough there? Like, do we need to go further into what that actually means and what people would run into? Especially in an ongoing basis where like machines often need firmware updates and things like that. And if they ran into issues where they adjust the machine and then now they no longer get firmware updates or something that makes their thing not run. I don't know if that's even a thing, but in computer world it is. So like I assume it could be on equipment as well.
Yeah. So I'm not sure what the sort of legal analysis of that would be. Statutes can be challenged for what's known as void for vagueness. If a statute is so vague, then someone can't comply with it. Those also tend to be very high bars for companies to meet. So I think just having the word technology, I'm not sure that is vague, that a company can't comply with it. And that's probably where you want to hear from your experts and your stakeholders about whether it makes sense to include examples. Even for myself, reading the FTC studies, I didn't realize how adhesives are used to like glue parts down so you can't remove it. You know, that's something that I wouldn't have known as a layperson. And so those might be the kinds of things you want to consider. But I wouldn't think that the word technology in and of itself is so vague that it would make your statute void.
Okay, cool. Thanks.
Hey, Justin, thank you.
Sure.
Appreciate your time.
Thank you, Chair Marcotte. Thank you, everyone.
Thank you.
And please feel free to follow up with me in our office. Great. Thank you, everyone.
Thank you.
May I have your attention, please? May I have your attention, please? This is a building evacuation. Gather your belongings if they are within reach and evacuate the building using the designated route for your